We're going to do three main things today. First, we're going to go over DBE developments that have been happening at MnDOT. Then we're going to go through the new standard specs that MnDOT has imposed on us and focus on the risk allocation that they've imposed. And third, we're going to have an industry panel discussion with people who especially know what they're talking about: Tim Werke, Mark Zeller, Dennis Banke, Manny Walk, and Butch Trebish. Now, I'll tell you what we are not doing today is we're not going to be marching through the DBE regulations in exquisite detail, nor are we going to be going through section by section in MnDOT's new specifications. Instead, when we talk about DBE requirements, we're going to be focusing on how to survive a good faith efforts challenge or effectively make one. In regard to commercially useful function investigations, how to avoid a false claims and the assessment of treble damages against your company. And then on the specifications, we aren't going to march through each section, as I've said. Instead, we're going to focus on the sections that transfer risk allocation. And then we're going to give you red flags of what to watch out for and practice pointers. I think my assistant Helen should have given each of you a zip takeaway from this presentation, and on it contains our PowerPoint, the redlined revised specifications as best as Word can show you the new ones as compared to the old, but they've been so overwritten by MnDOT that it's very difficult sometimes to figure out where they struck and what they added. Then we're going to give you our memos that we wrote for the AGC and MAPA analyzing some of the changes in greater detail. And if you really do want to march through the specifications section by section and find out what changes were made, well, we've given you MnDOT's PowerPoint to do that with all its 180 slides. Finally, we've included the AACE recommended practices. That's the Association for the Advancement of Cost Engineering. And those are the scheduling specifications which MnDOT has now imposed on us all in its new recommendations. Finally, we've given you a sheet to suggest seminar topics for us in the future, because we hope this will be the first of our annual MnDOT update seminars. Because there's so much going on with MnDOT, it's important to keep up. Make sure to ask for questions for Christine and I during this presentation, and that way we'll get the most out of it. So with that, let's focus on the new DBE requirements and what you need to know to get and to keep jobs. Now, when we're talking about DBEs, it's usually an alphabet soup. Broken down, that's GFE, good faith efforts. That's what you need to expend to meet the goals or try to meet them. CUF, that's commercially useful function. You've got DBEs must perform a CUF to avoid allegations of fraud. And of course, the DBEs and the TGBs are the minority and women contractors that we're talking about in the program. So let's evaluate the state of play. What are some of the recent developments that we've seen? We've been fortunate enough to get two. One is an April update from the US DOT. They did their own internal audit about the state of the DBE program, weaknesses in the department's Disadvantaged Business Enterprise program. Followed a month later by MnDOT's internal audit of its own Office of Civil Rights Department. Let's take a look at what they have to say about their own programs. Under the DOT audit, the DOT questions whether the department itself is providing an adequate DBE program management. And then they asked, do the recipients, that would be MnDOT and other states, sufficiently oversee and implement the DBE program? Finally, is the program itself achieving its objective of developing DBEs to succeed in the marketplace? In a nutshell, their answer is no, no, and sometimes. This is not a good report card. Some of the key findings. Well, they sampled, They sampled the system, and in 2009, $4 billion was given to DBEs, and it was distributed through recipients. They wanted to know whether there was adequate DBE management and do recipients properly oversee. They sampled 121, and They found at least 2 were not properly certified, got $5.4 million in payments that they shouldn't have. The certification staff in 5 of the 6 states admitted ignorance of the DBE programs and how to verify the DBE owner's personal net worth to qualify as a DBE. Recertifications on an annual basis were missing in 74 out of the 121 sampled. And then there was inadequate on-site certification to make sure that the DBEs were providing CUF through their key controlling officials. Again, not well done. 43 out of 106 files showed that on-site certifications check took place over 5 years ago. Well, what's the lesson from this? The lesson is do not rely on the state's certification of their DBEs. It is unreliable, so you can't depend on the state DBE list to tell you whether the DBEs are providing a commercially useful function. And let's look at some of the CUF findings. In Pennsylvania, a non-DBE did the work, siphoned off $136 million over 15 years to the DBE in basically a fraud. Only 3 of 14 states had regular job site inspections to ensure CUF, and New York did a compliance review on only 20 of 500 jobs. Now, this might indicate to you, well, gee, this low level of certification might allow me to get away with, say, using a DBE with marginal CUF or perhaps inadequate CUF. But you'd be wrong, because as we'll discuss later, the type of enforcement activity for lack of CUF is increasing exponentially. So, is the program working? The DBE found that the recipients do not adequately develop DBE firms to succeed in the marketplace. In Maryland, as an example, 5,000 eligible firms, but only 560 ever received the work. That's only 20%. In Maryland, only 4 firms consistently win the most contracts, about 100 out of 609. Often, due to the competitive advantages that a successful DBE gains from these programs, they have little incentive to grow beyond the DBE requirements. 59 of 120 DBEs were first certified more than 10 years ago, yet the goal of this program is that they grow out of the DBE program. And the DOT found that recipients often deliberately limit the amount of new contract dollars that they take in order to stay within the program. So what are the conclusions from the DOT? Well, we're getting many ineligible DBE firms winning contracts even though they shouldn't be. Majority of DBE firms, on the other hand, are not getting the work, and the DOT must take a more proactive oversight approach to ensure recipients or the states comply. That means the Office of Inspector General will be visiting MnDOT more often to make sure the rules are being followed. So, what does MnDOT say about its program? Well, they undertook procedure review, and they had several concerns. The first, that there were inconsistent goal settings by their DBE specialists. In other words, they weren't being performed to any recognized statistical standard on a consistent basis, and that poses constitutional problems. The calculation of achieved goals was unsubstantiated. There's no adequate monitoring enforcement in place, and there's a conflict within the department to remove DBEs that aren't properly certified or don't provide CUF, and yet to add them to grow the pool so that they have a successful program. Now, the DBE pool, MnDOT found, contained many companies that don't meet the requirements of the DBE programs. Inconsistent methods for goals, as I mentioned. And regarding the good faith efforts, well, MnDOT found that contracts cleared on good faith efforts were over 50%, but the audit found an overuse of good faith efforts in 2010 and 2011. But in 12, this was drastically reduced, and this is a positive trend. Frankly, I question whether that's a positive trend because the regulations require MnDOT to employ the good faith effort standards. And if you cannot meet the goal, and you have exerted good faith efforts, they're required to approve your bid. But MnDOT is saying here that it's a positive trend that they're not using good faith efforts and it's been overused. It's a troubling finding. They don't want the continued use of good faith efforts because contracts will be conditioned into thinking that they can get away with good faith efforts when MnDOT wants them to meet the project goals. Again, you can't be required to meet the project goals. All you can be required to do is make good faith efforts. This type of finding suggests that MnDOT will be trending toward a de facto quota of meeting the goals, which is also unconstitutional. Well, they found several companies that no longer meet the MnDOT requirements, and next we can conclude, where is this trending? Well, we expect stricter certification reviews of DBEs. We expect a crackdown on overuse of good faith efforts, according to the department. There will be more oversight by feds and state, and there'll be crackdown on DBE fraud. But in response to my original question, what's the state of play, I think we can conclude the rules aren't regularly being followed and the game's not producing the intended result. Now, there's one thing you can do with all this, is to make a constitutional challenge. And one of our clients has done so. Kyle Hart is representing Geyer Signal in a case against MnDOT and the Department of Transportation. And the claim is that the current program is having an unequal impact on certain types of non-DBE subcontractors. In other words, there's an over-concentrated burden on line items of work such as traffic control, trucking, and supply. Now, clearly, DBEs, or any small contractor, has difficulty performing the vast majority of capital-intensive work simply because they don't have the capital. Therefore, they try to enter the marketplace in areas where low capital is still viable. That would be traffic control, trucking, and supply, and landscaping. But if the program is intended to address alleged discrimination throughout the entire industry, focusing on DBEs in trucking, landscaping, and traffic control doesn't solve the problem. And the Supreme Court has held that the program must be narrowly tailored to address the harm at issue. The harm at issue is widespread discrimination, but we're overemphasizing and dealing with only one aspect of the industry to address it. That's the nature of this constitutional challenge. And second, the challenge suggests that the definition of good faith efforts is just vague. No one really can define it. And that's because good faith efforts require that you use a DBE contractor even if its price is higher than the non-DBE contractor. Well, fine. And you have to pay more for it. How much more? Well, as long as the price is reasonable, not unreasonable, then you have to use them. Who defines reasonableness? Well, MnDOT does, but it defines it after the fact. They refuse to tell you up front what that does mean, and you only find out later after your bid whether you've frankly guessed right as to whether you've paid more or sufficiently enough or whatever. That is an unconstitutionally vague standard, so the lawsuit says. But who wants to make constitutional challenges every time you're faced with a bid? Not many people. So let's focus on what you need to do to satisfy the good faith efforts standard. What are we talking about? Well, the regulations require that you make good faith efforts, and you can do that by either meeting the DBE goal or documenting that you tried as hard as you could. Trying as hard as you could means taking all necessary and reasonable steps and proving that even though you couldn't meet the goal, you did all sorts of efforts to do it. Now, obviously, that's a subjective analysis, so you have to document what you did. Now, I've got many clients who have lost projects because they couldn't demonstrate good faith efforts. And the reason they couldn't demonstrate good faith efforts is they simply didn't keep track of the documents and the efforts that they did and put it in writing so that they had something to deliver to MnDOT or any federal or state agency to prove what they did. So let's take a look what you need to do. You have to solicit interest with pre-bid meetings, advertising, written notices, and you have to allow sufficient time for the DBE to follow, to respond. What MnDOT often looks for is not just the initial solicitation, but then the follow-up to the initial solicitation. Another email round, another round of faxes, someone who's actually made the calls and logged the calls to show that they've been made. As you can see, the mantra, document, document, document. Sheer volume of paperwork, regrettably, is important, but it is. You know, the gestalt of the effort, and which can only be proven by documentation. Now, I know many DBEs legitimately say, stop pestering me. I'm not interested in this particular job. Leave me alone. Unfortunately, you can't listen to them. Because if you don't do this, then MnDOT's going to criticize you for not contacting them. And it's not going to be enough for you to say, they told me to stop calling. Oh, I'm sorry. You don't have the documentation that you followed up 3 times with this person who told you to leave them alone. This is the unfortunate dance that we're stuck in. So, you have to break the work out into economically feasible units. Oftentimes, my clients say, yeah, well, I did it for everything but my work, but I didn't want to do it to my work because that's what I was going to do. That's not enough. You have to even break out the work you intended to do and offer it to the DBE community. Now, you can do this by normal work categories under the divisions, or you can break those divisions up. To take an example of your painting, you can offer one side of the building to a DBE to do, not all 3. I had a case once where a DBE subcontractor submitted a price for the import and export of materials. The price really was too high, but he broke it out so that his import part of the price was relatively low. He was apparently expecting to make his money on the export. MnDOT said, well, look, you could have taken his import price, rejected his export price, and he would have been competitive. Of course, it doesn't work that way, but MnDOT wants you to make the inquiry, document that you've made the inquiry that you asked him to break out his price and split it in an uneconomical way, and would he accept it, and why not? And once you've got that good faith effort, you've proven your due diligence. Of course, you've got to make sure you give the DBE all the adequate information that they may want about the project. And that's easy to do now, more easy than it was with electronic communications and PDFs, and you can send PDFs out with all the information to assist them. You can even inquire a list of DBE questions. What would they like to know about the plan? Now, I'd even encourage soliciting out-of-state DBEs if you're on the border of a MnDOT project. That should technically not be required because the goal should be set with participation from Minnesota DBEs. But recently MnDOT has criticized people for not going out of state, so as long as they're going to improperly criticize you for not going out of state, go out of state and solicit people there. It's only an email click away. Now, negotiations are also required, and this is very controversial because it sounds a lot like bid shopping and bid chiseling. If the price is too high, unreasonably high, you're supposed to go back and demand a lower price, but and MnDOT doesn't think that that's bid shopping, and so be it. But you have to have evidence of these negotiations, and of course that's very difficult to do when they submit their bid to you 5-10 minutes before the bid date is due. So at least what you have to do is solicit the bid before the deadline. Have evidence that you've got the bid in hand before the deadline. This will allow you, after the deadline, to go back to them and continue to negotiate, but you can't solicit more participation after the bid due date, according to MnDOT. You used to be able to do that. A couple of years ago, you had 5 days to increase your participation. No longer. You've got to have your participation in place as of bid time, and then you've got 5 days to document who you're going to use. But in order to negotiate, you've got to solicit by the bid date. Well, I've said that additional cost is not a sufficient reason for rejecting it as long as the cost is reasonable. Unfortunately, MnDOT thinks that cost differential should be judged not upon the line item of work in question, but in comparison to the entire job. Now, any line item on a relatively small item of work in comparison to the entire job will be de minimis. It will be so small that by definition it would be unreasonable to accept it. And this is a troubling trend by MnDOT. The only thing I think you can do is to document the differential, document that you tried to negotiate a lower price, and then conclude that based on other bids, this particular one was unreasonable. You must provide good faith efforts assistance, bonding, lines of credit, and insurance. This is difficult to do. At least you can introduce and have a record of introducing DBEs to your contacts as evidence of good faith efforts. Again, documenting this type of effort is very important. If you have a SIP on a particular project or are considering instituting a rolling SIP, that's a good thing. Not only does it better comply with a new anti-indemnification statute that the legislature has passed, but often DBE contractors have higher rates of insurance, and renders their bid more costly. If you have a SIP, you can take their price without the insurance component to it, and you can get more competitive pricing from them. Better participation, which is the goal. Again, as long as we're in an email society, you really should document that you've contacted all these organizations, the women and minority organizations, contractor groups, business assistant offices. Now, I've just listed to you a tremendous burden of documentation in order to survive a good faith efforts challenge. But that seems to be necessary. How are you going to do it? Your PMs are busy and swamped as it is. Many firms have decided to outsource this to DBE coordinators, outside DBE coordinators, or hired their own separate staff person to put this type of documentation together when necessary. Otherwise, it's very difficult to come back to MnDOT saying, I've met the goal, I think I made the good faith efforts to you. Let me tell you, they don't want to hear it from you. They want to show it to me. Show me the documents. Now, in this type of situation, they'll compare your performance to the good faith efforts achieved by other bidders. Look, bidder X hit it and you didn't. That means you didn't exercise good faith efforts. Well, not true. You really should look to the average of all bidders. Just because someone took a lot of high prices and met the goal doesn't mean that that was reasonable. And then you have to look, and you could possibly challenge, did the other bidder really meet the goal? I mean, for instance, that suggests, did the other bidder use DBEs that provided a commercially useful function, or CUF? There's been a trend recently to use exclusive agreements with DBEs as giving the bidder a competitive advantage. If there's one DBE who can perform a great deal of work, and everybody is hoping to use that DBE, if one person snaps him up with an exclusivity agreement, then that person's got a great competitive advantage. That one bidder can meet the goal, and there'll be a challenge for the others to meet the goal. Is that appropriate? Well, I can tell you that the Metropolitan Airports Commission doesn't think so. They will not allow DBE credit to be claimed if there is an exclusivity agreement because they want full and open competition. MnDOT, as yet, doesn't think so, which is unfortunate. You know, they set the goals based on what DBEs they think are available. And if one of those major DBEs decides to go exclusive, that really undercuts the basis of the goal itself, doesn't it? So if you run into an exclusivity issue, you wanted to meet the goal, but some DBE tells you, I'm sorry, I'm locked up, I can't talk to you until after the award, that's a basis for a challenge, I think. And because MAC now prohibits it, I think MnDOT would have to listen to that type of challenge. And can challenges be made to the DBEs used by the other successful bidder? Yes, I think it can. And that brings us to the CUF question, which I want to talk about now. What I think you need to do if you're going to make a challenge to someone else's DBE participation is you have to know the certification requirements and you have to know the requirements for commercially useful function. Now, I'm not going to go over the certification requirements. As I said, those are quite tedious, and we can cite you to them if you want later. The commercially useful function is useful because not only you need to know it for the basis of a challenge, but you need to know it to protect yourself from a false claim allegation. There we go. So, as I've said before, commercially useful function is a standard that's applied only to DBEs that are already certified. So, has a DBE been cleared in the certification process? Great. But you can't rely on it, as I've said, because these audits have just shown us that both the DOT and MnDOT is historically lax on their oversight of the certification process and whether someone actually provides CUF. Now, you provide a CUF when you're actually responsible for execution of the work, for actually performing it, managing it, supervising it, and all that. And there's many factors that you need to look at when evaluating CUF. Here's a cite to the DOT spec that allows you to read it in greater detail. But you have to evaluate the work and determine whether it's consistent with normal industry practice. Obviously, if you give your work to a CUF, he performs 3% of it, subcontracts the rest of the work to a non-DBE subcontractor, that has no CUF. There's no commercially useful value being provided by that subcontract. The DBE has to be able to negotiate price, quality, quantity, all the things that you'd expect a normal business to do. What the CUF requirements are designed to do is shake out what they call an extra participant in the process, someone that doesn't provide any normal value, simply to obtain the appearance of DBE participation. What do you really look for when you evaluate CUF? Control of operations, really. Do they hire and fire? Do they schedule? Do they order? Do they do things that a contractor's supposed to do? Look, if there's no supervision by the DBE, or its superintendent isn't a regular employee, he's not under the staff's not under the DBE's control, and the DBE owner really doesn't know what's going on in the job site, that ought to be a red flag to you, because if it's investigated, I can guarantee you it will be a red flag to the federal government. How do you protect yourself? Well, you protect yourself by, again, documenting that you've actually gone out and investigated what this particular DBE is doing. You may have used a DBE in your bid to MnDOT, but if you discover that that DBE really isn't providing CUF like he said he was, then you're under an obligation to go back to MnDOT, report that to MnDOT, say, look, I'm very concerned about this, didn't know about this. I need to take this DBE off my reporting form. Now, MnDOT will likely say, well, then you better find someone else, but you're not under an absolute obligation. You're not required to. All you're required to is to use good faith efforts to find someone else. But you need to do that. But far better to take that suspect DBE off your rolls after you've discovered it than to keep doing it. Because if you keep doing it with knowledge, that's fraud, according to the federal government. Here's some red flags to keep in mind about equipment. If you're leasing equipment from the prime contractor and you don't own it yourself as a DBE, that's a problem. If you've got magnetic signs of your company over your general contractor's truck, that's a problem. If DBE truckers really are leasing trucks and cabs that are owned by prime contractors who are non-DBEs, that's a problem under the trucking rules. If you're a material supplier, you got to negotiate price. You have to have a yard in which this material can be delivered. You have to be a regular supplier. You got to pay for the materials yourself. Otherwise, you're just a broker. And you might be able to get 3% for that, but you're not going to get the full 60 or 100% that you want to claim for the supplier. Now here, this would happen between Met Council and MnDOT. There was a DBE supplier of pipe that the Met Council took a hard look at and said, in a bid protest, saying, no, I can't certify that person has cuff. And they disqualified the bidder who used that person. Now, on a MnDOT project, the same supplier was used, but MnDOT said, well, I find that to have cuff. This is a problem. If you're a contractor and a bidder, how do you know which contractor you can use? Well, we all ought to go to MnDOT and ask them to do a better job shaking out their DBE contractors so this doesn't happen to us. But if this does happen to you, now that you've got disparate treatment between two separate entities, you have a basis really for a protest of saying this is arbitrary capricious to throw someone out on one project and accept them on another, and it shouldn't have happened. You have to look at their performance. Does it comply with normal industry standards? Are they subcontracting more than 50% of the contract value? That will be a red flag to any auditor. Is a DBE working for only one prime? That again suggests excessive control. Is the volume of the work beyond the DBE's normal capacity? That's an issue, of course. Now, this goes, what we've been talking about goes to whether you can support a challenge, you can support your own bid. Why am I also talking about this? Well, because of False Claims Act liability. There are federal and state False Claims Acts, and they can subject you to criminal liability if you're doing something wrong intentionally. If the government thinks that you didn't have a black heart, but you were still doing it wrong, they'll pursue you civilly. And liability is imposed under these acts for making a false claim. Well, what's a claim? A pay application is a claim. All right. But every pay application now, according to the new MnDOT specs, says you must certify with every application that you are complying with all laws related to this contract. That means the DBE laws. So every pay application, you're certifying that your DBE contractors possess cuff and that you're making good faith efforts on this job to increase your DBE participation. So they've now implied False Claims Act liability in every pay application. What's the big deal about that? Lots. Because if they find out you're violating the DBE regs, they'll assess liquidated damages. Often that's specified as the amount of the contracted issue or the amount that the contractor falls short of the goal. They will threaten debarment. They'll claim unjust enrichment and disgorgement of the amounts that they've paid you. Plus, under the False Claims Act, they'll fine you about $10,000 per pay application. And then they're going to treble their actual damages. If this isn't enough, they define their actual damages as the entire amount of the contract. Not just the DBE's contract, your contract for the entire job. And if you don't pay, they'll threaten, as I've said, to debar you. So this is tremendous leverage. This is why this is so frightening, really. And that's why you must document what you're doing. Because the Office of the Inspector General has realized this is a whole bunch of low-hanging fruit. Revenues are short. How to increase revenues? Well, we can make these False Claims Act allegations and demand treble damages. And they've been doing this a lot in Minnesota. And it's increasing from 2003 to 2008. The OIG, that's the Office of Inspector General, had 49 indictments, $42 million in recovery. In 2009 to 10, they've increased their investigations by 70%. 29% of the OIG's current enforcement investigations relate to DBE fraud because it's so profitable. The most common DBE scenario that we'll find is that a non-DBE contractor partners or creates a sham DBE that meets the eligibility on paper but doesn't comply with cuff. That's why we've been discussing cuff. And remember, all these DBEs that have been subject to these investigations have been certified already by the state as legitimate DBEs. And the paper is littered with claims relating to this. I'll just go through a couple. In 2007, a Michigan contractor gets hit with $11.75 million for claiming DBE credit for a subcontractor. New Jersey, this is not surprising, $20 million for work done by a non-DBE. It claimed as DBE credit. Even credible contractors like Skanska settled DBE fraud claims for close to $20 million. It's sure a lot better than being debarred. So, what sometimes causes a problem? Well, sometimes you're offered too much help because you really want the DBE to succeed. Here's an example. One of our clients, a DBE electrical contractor, hired a DBE subcontractor. That subcontractor didn't know how to set light posts. So the contractor shows them how to set the light posts and gets a false claim act threatened against them because they were doing the DBE's work for them. All right. A concrete contractor assists a DBE with a startup loan. That's what you're supposed to do, remember. Extend loans and financing. Leased services and personnel. Lease them for a price. This was rejected by a later OIG investigation because you're giving too much help to the DBE. And ironically, this help was done pursuant to a mentor-protege agreement that was recommended by the state, by MnDOT. Well, this is a lesson. Watch out for what you do with mentor-protege agreements. They are not a panacea. They're not a safe harbor. Why is that? Well, you think when you enter into a mentor-protege agreement, you can give more assistance. After all, you're the mentor. You've got a protege. You're supposed to give help. But not according to the federal government, because you can give your protege too much help again, because that protege has to provide cuff, whether they're your protege or not. And so even if MnDOT approves your mentor-protege agreement, that doesn't mean you're safe. What will happen often is that the federal government will come in and evaluate the mentor-protege agreement and say, well, in our opinion, you gave too much help. Your defense is, well, I got this approved by MnDOT. This is their suggested mentor-protege agreement. MnDOT will then say, oh, I didn't know those facts. Had I known those facts, gosh, I wouldn't have approved it either. So you're thrown under the bus because MnDOT does not want to threaten its status with the federal government, because it can lose federal funding unless it properly enforces its DBE program, and it just doesn't want to disagree with the OIG office. It's not a good situation. Again, here's an example of a mentor-protege agreement. DBE wanted to install large pieces of specialized electronic equipment. With the help of the recipient's representative, MnDOT's representative, they formed a mentor-protege agreement. MnDOT helped draft the agreement. They checked up on the progress of the mentor-protege agreement throughout the job. Years after the fact, the OIG comes in and says, well, this DBE really didn't have full control of ordering the equipment. Of course not, because it wasn't used to ordering this type of size of sophisticated electronic equipment. It was relying on its mentor to help. But there was a False Claim Act allegation, even though it was an approved mentor-protege agreement. Another problem, a DBE supplying contractor's product. Now, the non-DBE, the mentor, hires a DBE specialist to make sure he's doing it right. They work with the MnDOT, draft the mentor-protege agreement again. Years later, federal government comes in, finds too much help has been provided. So what are some of the conclusions that we should draw from this? Well, scrutiny of the DBE program is at an all-time high because of these audit results. Do not rely on DBE certifications because you are inspected to investigate them. Not MnDOT, but you. You're responsible for making sure that they have cuff. So you're in this catch-22. You don't want to lose the job because you want to make good faith efforts and include as many DBEs as you can. And that encourages you not to look too hard at cuff because you can self-select yourself out of the bid. But on the other hand, you don't want to risk your livelihood by including DBEs that really don't have cuff. It's a dangerous position to be in. And as to the DBEs, you yourself can be liable. You've got to be cautious and accurate and diligent about filling out your certification forms, because now the federal government is no longer interested in going after the non-minority general contractors. They are now beginning to go after the DBEs themselves for participating in what they claim is a DBE fraud. What can you do? Well, as I've said, investigate CUF. You've got to not only investigate, but interview these people that you hire. And I know that adds an additional layer of overhead and enforcement, but with what's going on right now, it's a prudent investment to make. And if you want to maintain your job, want to get a job even though you haven't met the goal, remember you've got to document your good faith efforts. That's what's important. So, that's the happy state of the DBE market in our fair state. Does anybody have questions before I shift gears? Well, it's a very sobering.
It looked like one of the documents when you were talking about the good faith efforts of the mentor partnership a couple slides ago. At the bottom, one of the things they went after was the fact that it looked like that they offered some loans, or there was some loan participation they had provided to DBs, some loans that they didn't disclose or something.
Right. Because OIG came in and didn't like what was happening, the MnDOT and MUCP took a look at the application for certification. And they said, well, there's some loans between the mentor and the protege that we don't like. Actually, if they had looked into the loans in more detail, they were above board. They were arm's length loans, but MUCP was in a hurry to comply with what they thought OIG wanted, which was decertification of this particular DBE.